Justice Kagan?
Mr. Schnapper, can I give you three kinds of practices, and you tell me which gets 230 protection and which doesn't? So one is the YouTube practices that you're complaining of, and we know you think that that does not get 230 protection. A second would be Facebook or Twitter or any entity that essentially prioritizes items. So you're on Facebook and certain items are prioritized on your news feed, or certain tweets are prioritized on your Twitter feed, all right? And that there's some algorithm that's doing that and that's amplifying certain messages rather than other messages on your feed. That's the second. And then the third is just a regular search engine. You know, you put in a search and something comes back, and in some ways, you know, that's one giant recommendation system. Here's the first item you should look at. Here's the second item you should look at. So are all three of those not protected? Or what happens to my second and third? Are they protected or not protected? And if they are protected, what's the difference between them and your practices?
Certainly. So let me start with a search engine. There's a lot of discussion in search engines, but there's not a specific provision in the statute that says search engines are protected. The question is, do they fit within the language of the statute? So if I ask a search engine for stories about John Doe, and it gives me a list, and if I click on one of them, it turns out to be defamatory, they're not liable because they...
Well, they just gave it to you. It's the first thing. They've just prioritized it. They think it's really a great one to click on.
The mere there are multiple questions here. First, are they liable just because what you clicked on turned out to be defamatory? The answer we think is no. Secondly, what if the snippet that they took from the John Doe document said John Doe's a shoplifter? And the answer is they're not liable because they didn't write that. It's publishing third-party content. The third question is, could they be liable for the way they prioritize things? And the answer is, I think so. It's going to depend what happened. And the example,
So even all the way to the straight search engine, that they could be liable for their prioritization system?
Yes, there was let me,
okay.
If I might continue.
I appreciate go ahead, I'm sorry.
Those are the facts which led the European Union to fine Google 2.3 billion euros because they use prioritization to wipe out competition.
Okay, so here's...
things that we're selling.
Yeah, so I don't think that a court did it over there. And I think that that's my concern, is I can imagine a world where you're right that none of this stuff gets protection. And, you know, every other industry has to internalize the costs of its conduct. Why is it that the tech industry gets a pass? A little bit unclear. On the other hand, I mean, we're a court. We really don't know about these things. You know, these are not like the 9 greatest experts on the internet. And I don't have to accept all Ms. Blatt's "the sky is falling" stuff to accept something about, boy, there is a lot of uncertainty about going the way you would have us go, in part just because of the difficulty of drawing lines in this area, and just because of the fact that once we go with you, all of a sudden, we're finding that Google isn't protected. And maybe Congress should want that system. But isn't that something for Congress to do, not the court?
Well, I think the line drawing problems are real. No one minimizes that. I think that the task for this court is to apply the statute the way it was written. And if I might return to a point that Justice Alito made, much of what goes on now didn't exist in 1996. The statute was written to address 1 or 2 very specific problems about defamation cases. And it drew lines around certain kinds of things and protected those. It did not and could not have been written in such a way to protect everything else that might come along that was highly desirable. Congress didn't adopt a regulatory scheme. They protected a few things. It will inevitably happen, and has happened, that companies have devised practices which are maybe highly laudable, but they don't fit within the four walls of the statute. That will continue to happen no matter what you do. And the answer is when someone devises some new practice that may be highly desirable but doesn't fit within the four walls of the statute, the industry has to go back to Congress and say, we need you to broaden the statute because you wrote this to protect chat rooms in 1996, and we want to do something that doesn't fit within the statutes. And using thumbnails would be a perfect example of that.
Thank you.